Good evening. This is Rahul Reddy from Reddy Neumann PC. Every Tuesday evening at 5 p.m. Central Time, Reddy Neumann PC brings in immigration updates. Emily, what do we have today?
So we've been hearing a lot of rumors about F-1 students specifically being deported from the airport in Abu Dhabi when they're trying to travel back into the U.S. So we've been trying to chase down some of the details on this. It's kind of rumors are spreading like wildfire. We're seeing WhatsApp messages and posts online. So we want to give you an update on the actual facts that we've been able to determine based on discussions with people who actually were in the situation. We also want to answer some questions about the upcoming H-1B electronic registration process. One of the top questions I've been getting on my blog is, can I travel during that 20-day registration period? So we'll talk about that and answer any other questions you have. Another common question we get is, what happens if you've been laid off while you're in H-1B status? When does the 60-day grace period apply? What options do you have? And also, one of the common, immigration issues that come up is choosing between adjustment of status or consular processing of your green card. What are the benefits of each, and why would you choose one or the other? So we wanted to kind of give you an overview on those. So what's the story with these students entering in Abu Dhabi?
In the past 1 week, we have noticed that there are a significant number of people who have been deported or turned around. What is the actual word? That it's expeditiously removed or withdrawn the application from the Abu Dhabi airport. There is a pre-clearance in the Abu Dhabi airport. Not many airports have that, but Abu Dhabi airports have. All these were coming on a student visa, at least the people that we have spoken with in the past 1 week. They were all coming on a student visa. And in the pre-clearance, the CBP determined that these people violated their student visa and then requested or kind of forced the students to withdraw their application into coming into United States. And then they were being turned back and being sent back to their home country, which is India. This has been, only happened in the past 1 week, Emily. There are some instances that happened about 2-3 weeks ago, 4-5 weeks ago, but most of these incidents happened in 1 week. There are some common things that I found among these students that you might also your consultations. One thing was that they were all been asked to provide the cell phone. They were all been asked to provide the bank information. They were all been asked to give the passwords out for the bank information. They also asked them to show the WhatsApp and some of the pictures, Google pictures and other things. These are the common things that I found out what were being asked. When it comes to the violations of the student visas, at least the allegations by the CBP is that the CBP is alleging that these people have worked unlawfully in either gas stations, restaurants, or in grocery stores. These are the 3 things that we found out that. Emily, can you describe, when these people are faced with, when the CBP is asking the question, hey, please provide me your cell phone, give me the password of that, what rights do the applicants have to come into the United States? Can they refuse it? If they refuse it, how they can, and what are the options that they will have?
Yeah, so, electronic searches of your cell phone, laptop, those are allowed for non-immigrants trying to enter into the country. So they absolutely, at least at this time, have the right to ask for that information. At that point, typically your options are, if you don't provide it, you're not going to be let into the country. So if you are intending to come into the United States, I think most people feel pressured to give that. And if you chose not to, really your option is, I don't want to give this information, so I'm withdrawing my application for admission and I'm going to return back to my home country on my own. That's really your options, is comply with the request so that you can hopefully be admitted, or refuse and withdraw your application for admission and go back home. Now, if you are in that situation and there's potentially something in your background, something in your phone, something in your WhatsApp that could be problematic, you may want to consider choosing not to turn over your device or not to turn over those passwords and request to withdraw your application for admission instead, because what we're seeing with these students, once they do turn that information over, it's very easy for the CBP officer to see that there's been unauthorized employment, and then you could be subject to expedited removal. If you go through that process, you're barred from coming back for 5 years. So it's a pretty big risk to take to go ahead and turn over that information if you know there's something in there that could be problematic. You're basically asking to be removed and end up with a bar.
So in the situation where you've been requested by the CBP to give the passwords of your cell phone, and you are at risk in both. If you give it, then you are potentially exposing every life aspect of it to the CBP officer. If you don't give it, as Emily has pointed out, then you are withdrawing your application coming into the United States, and that will be on the record that you withdrew the application there. The most common things that I've noticed in the past 1 week with these about 7 to 10 people that I've had contact with was that there have been alleged by the CBP, as I've explained before, that they have worked outside the perimeter for which the student visa OPT or STEM extension was being permitted for. The allegation was that they're working in the gas station or restaurant or grocery store. These are the 3 common things that the CBP has alleged in the past 1 week. One of the advice that I would give is that if any of the students have at any point of time had any violations that or even possible violations, I would immediately I would recommend the people to contact a lawyer to skim through all the information. And a lot of times when these people, when I have consultation, they ask the question, how did they find out? The main question is obviously when they look into the bank record, that's what they're looking into, is the bank record to find out where the cash is coming up from. And they're looking into the pictures, they're pointing out, hey, here's a picture that you have it, that you are in a restaurant, not in a restaurant sitting eating, but in the other location. So gas station, certain other things, liquor store that I've noticed, these are all the things that they're asking. I believe that it's not that they're finding that information at the time after you came into the airport. They already have the information well before and they're picking you out based on information that they already have. That's my guess though. Yes, people may argue no, based on the information that we have provided at that point of time, they got that information. But I believe strongly that they had that information before you even came to the airport. They had that information. When you book the airlines, they have that information. Nowadays, everything is, eye recognition. In fact, I spoke with a CBP official in the mid of 2019. They're actually discussing about no need to have passports anymore, Emily. So, wow, you guys are improving very much. And they were telling that everything will be an eye recognition or whatever the facial recognition is, that they have that information with them at this point of time. This is a discussion I had in the AILA conference with the CBP official, is that the passport is redundant. In other words, they have all the information before they came in. That is what I am assuming. Emily, you have any other guess?
Yeah, it would seem unusual. The cases I've been in discussions with people, they describe multiple students all on the same airline, same airport, landing at the same time. A group of them are all selected to come into secondary inspection. And how would they have enough time to go through all of those cell phones and documents? How would they find that one picture of somebody where they're not supposed to be, or that one transaction on the bank account so quickly?
So quickly.
I mean, obviously they know where to look, but at the same time, if you've got months worth of bank statements and they're each several pages long, are they really looking through every single one of them, or do they already have an idea of what they're looking for and they're just getting documentation. So I think you're right on that.
Yeah, and the way that the secondary inspection happens, if you were to face in the Abu Dhabi airport, is like this is what's going to happen. They will pick you out and they will ask you more questions, and the airplane flight is going to be missing, so you're going to miss the flight, and they're going to detain you. First, they will interrogate you for about half an hour or so. And if you don't agree with those things, they'll say, okay, we'll come back in 2 hours, and they'll come back in 1 or 2 hours and maybe 3 hours. They'll ask you more questions. Then they will leave you for a while in that particular room, small room. They'll come back after 2 hours, and this may go on for up to 8-9 hours until you break down. And this is the most common thing that I've noticed in the past 1 week to 10 days in this Abu Dhabi airport. These incidents did occur previously in a lot of other times too, but not as such great incident what happened in the past 1 week with the Abu Dhabi airport. So if you think so, you have anything that to do with employment out of the perimeter for which your student visa or OPT has been granted, please contact a lawyer. If you think so, you work, nobody's looking at it, you are in a digital era, I think so you need to be corrected with regards to what your thinking process is in the digital era. You better adjust to the digital era right now, otherwise you're in trouble either way. So please, if you have ever worked on outside the perimeter, like if the OPT is there, you're working as you're doing master's degree, you have an OPT, you work for a software company, absolutely that's not a problem. If you have worked in a restaurant or something, that definitely is an issue. Also, if you have worked in, for example, if you have a master's degree and you have an OPT, you are undergoing through training to a particular company though, a software company, please have information with regards to what kind of training that you have gone through with that company. It is essential for you to have it, especially when you're traveling it. You may want to have that accessible in there, or you may want to even carry it in another format, so easily available for the period of employment that you do, even if it is within the perimeter of your employment scope that has been given for the OPT or STEM extension.
All right, so next we want to talk about the H-1B.
Emily, before we go in the, what I noticed in the Abu Dhabi airport was that typically when they request the students to, when the students admitted that they might have done some wrong things, and they allowed the students to withdraw the application. They have given 2 options. What do you recommend in the options when you're in an airport and you're stuck there and they will ask you to withdraw the application, or they will tell you that they're going to deport? What is the option that you would recommend?
Yeah, I would definitely lean towards the option of withdrawing the application for admission, although that will be on your record. It does not bar you from obtaining a new visa in the future or coming back to the United States, whereas if you end up being removed from the country, that could be a bar to getting another visa, a bar to you coming back, making you inadmissible, possibly not eligible for a green card in the future. There's a very big impact if you end up going through the removal process versus withdrawing your application for admission and returning home.
Emily, when you are being turned back from the airport though, they used to be giving the statements of I-867A form or I-877 form. I haven't noticed that in this particular incident of Abu Dhabi though, except for one person, they haven't given the statement. Can you explain what that form is? And they should request for the form if they're not giving it.
Right. So these forms are basically a sworn statement of what has happened during your detainment period. What were the interview questions asked and what were your responses? So it's a typewritten form that has basically line by line, what did the officer ask you, what were your answers. It might not be the entire conversation, but the important parts of the conversation. And then you normally will sign that. It's a sworn statement, meaning that you've reviewed it and you've agreed that everything that's typed up there is accurate. And you should ask for that because it's really important for to provide that information to an attorney if you end up in this situation, so that we can review exactly what happened, what were the issues. Because when I'm talking with clients, a lot of times they're very confused about what was the exact thing that caused the trouble here. What did I do wrong? Why did I end up in this situation? And when we get that sworn statement, we can clearly see this is where things started to go wrong. This is exactly why they made this decision and asked you to withdraw your application for admission. And that gives us more ideas or ways for moving forward in the future, what changes need to be made, what options you might have. So if you're in that situation and you are requesting withdrawal of admission, make sure you also get a copy of any sworn statement, any document you've signed from the officer.
Emily, so on the travel of when the H-1B lottery system is going on, when we are in the electronic registration process, can they travel at that point of time? Is it recommended to travel?
Yeah, so with this electronic registration process, there's really nothing being filed. So it's not like at that point you've requested a change of status. The main restriction that we've said all year, like for years and years and years, I've told people don't travel between April and October, because your change of status will be automatically abandoned because your H-1B is pending. Well, here, you haven't requested your change of status yet. Nothing's technically been filed on your behalf. All they've done is put your name in the hat. I don't see anything in the regulations that would suggest that there should be a restriction on travel. So I think technically, yes, you should be able to travel during that time without having any kind of impact on the H-1B. You could potentially, even if you are selected, travel in April or May and then come back in and file in June, because now we are going to have this 90-day filing period. So that seems to be a benefit. Whether you should travel during this time, for F-1 students specifically, when you are coming back into the U.S., you need to have your valid visa stamp, you need to have the I-20 endorsed for travel, you need to have time left on your OPT or be continuing your studies. But you also have to be able to demonstrate to the officer that your intention of entering the U.S. is in line with the visa that you've been entering on, which is the student visa. That may be difficult to do when you're coming in on a student visa but planning to file an H-1B, or your name has been put in the lottery. Or you also have to be able to prove your non-immigrant intent, that when your period of study is done, you're going to return to your home country. Here, you're coming back in saying, when I'm entering on my F-1, I intend to return home, and then you're going to turn around and file an H-1B petition. So there are some risks there that you could be denied entry when you're coming in during the registration period. So technically, yes, I think it is possible to travel. Is it safe to do so?
No.
No, I would not recommend it.
Emily, on the H-1B status, if somebody gets laid off, what are the options that they have?
Yeah, so assuming that there's time left on the I-94 of your existing approval for the company you've been laid off from, you do have the 60-day grace period that allows you to find a new employer and file an H-1B transfer within the 60 days. So when does that 60-day period start counting? It's from the day you stop working. So from that point, you have 60 days in order to file a transfer to another company. You also can file a change of status. So for example, if you are on H-1 and your spouse is also on H-1, you would have the option of filing a change of status to H-4 during the 60-day grace period. The important thing to know is if your I-94 is expiring during that 60 days, your 60-day grace period is going to be cut short and limited only to the day your I-94 expires. So in that situation, you have to file your transfer by the time your I-94 expires. I think the 60-day grace period has been a huge benefit to a lot of people. Most situations I come across, people are able to get the transfer filed within the 60 days. If you can't file it within 60 days, I think the safest option would be to exit the country. Once you do find the new employer, you're not subject to the cap, so you can always file at any time of year. have the new employer file a new petition that's not subject to the lottery, request premium processing, get it approved in consular processing, and then come back in either with your existing H-1B stamp if it hasn't expired or after getting a new stamp. That's usually your best option if you can't get something filed within that 60-day grace period. I don't know if you have any other
I mean, if they
options.
have an option of changing the status to H4, they might want to consider into changing to H4 visa status.
Yeah, maybe even doing that as a backup.
Yeah, as a backup,
Do it
whenever you lose the
anyways.
job, if you have a H4 option, just throw the H4 application out there, and then if you get an option of moving to another company within 60 days, you can. But F1 is not an option because you have to maintain the status until your F1 is approved, so that's not an option that you should look at. Either looking if you have H4 or otherwise, as Emily has pointed out, going outside the country. Emily, adjustment of, we deal with business immigration, so let's address only in the business immigration sense. Is the adjustment of status or consular processing, which one is better?
Well, I would say that 99% of our cases, we do adjustment of status. Adjustment of status
As
means,
of now.
As of now, right. You are in the United States, lawfully present in some sort of non-immigrant visa category, and your priority date becomes current, and now you can file the adjustment of status while you stay in the country with USCIS. The benefit of that is the process is a little bit less cumbersome, it's a little bit faster, and you get an EAD card and advanced parole for you and all of your dependents that file along with you. Now at this point, those EADs are taking 8 months to receive, but at least that provides a backup employment authorization and way to travel in case for some reason you can't use your non-immigrant visa or you end up losing or not having enough time left on your L1 status, for example. So those are some of the major benefits of adjustment of status. So most people that we work with do choose that option unless they're not eligible. One thing that makes someone ineligible for adjustment of status is if they've had unauthorized employment for 180 days or more at any point in their background. So if you have an employment situation or you've been in the US but fell out of status and overstayed by more than 180 days, you're not eligible to adjust status. You have to choose the consular processing option. That means that your approved I-140 petition first has to be sent to the National Visa Center. They are going to do some kind of initial intake. They're going to gather your documents and make sure everything is in the file. Then they are going to transfer your file to the consulate in your home country for an interview to be scheduled. You go in for your interview, and then they approve the green card there, and then you travel into the United States. The reason I feel like that's a lot more cumbersome is it's been quite a hassle dealing with the National Visa Center. Their CEAC website is very glitchy. Sometimes it works, some days it doesn't. Sometimes you can pay the fees, sometimes you can't. Getting everything to the National Visa Center, it's always been a hassle. They lose documents all the time. You have to resend things multiple times. Just a lot of back and forth. You have to get the police clearance certificates from any place you've ever lived outside the US for more than 6 months, right? And so there's just a lot of additional things that are needed for consular processing that are not necessary for adjustment of status.
Yeah, definitely, unless you're outside the country, it doesn't make any sense to go for the consular processing. It's burdensome. Sometimes it's more costly to go through lawyers, so adjustment of status is definitely. I want to go to question and answer assembly as we normally do. One Rajesh has this nice question. His mom's visitor visa, he is on a visitor visa. Her passport is expiring in 8 months, but her visa, that means the B2 visa, is expiring in 2026. Once her passport expires, she's going to get a new visa. Does she just have to take 2 visas to come, old passport and new passport to come into the United States, or does she needs to get a new visitor visa? That's a question he asked. Rajesh, she doesn't need a new visitor visa. She can use the same visa that for which the passport is expiring 8 months from now. That visa, which is valid until 2026. However, she needs to carry both passports at all times. Rajesh, as a safety, what I do is that whenever I see a passport like that, I take it from them, I staple them from the back. so that they never take only one passport. Whenever I see two passports, the visa on one thing, I take it, staple from the back side. Boom, that's it. They then staple it, they have to take both passports. In that way, she'll be safe.
MK Rayaparaju from Facebook has a very common question, which I understand the reasoning for it. It's time to file the H-1B, currently on F-1 with OPT. This year's the last year that you have the chance of going in the lottery, and wants to know if it's okay to file in this registration process with multiple employers for different client projects as a way to increase chances in the lottery. I definitely have to recommend not doing that. We've seen so much fraud, so many cases that seem like they get approved and then 3 years, 6 years, 10 years later.
Right now they are revoking mostly that filed in 2016, Emily. The ones that have been filed for duplicate, most of them that I see is in 2019, November, and all the way to right now are 2016 cases.
Yeah, so yes, people have done that in the past against our advice. We've been telling people not to do this for years, and they got approvals. Yes, you might get an approval. However, like Rahul said, right now in 2019, 2020, we're seeing tons of 2016 approved H-1Bs being revoked because they were fraud or misrepresentation, because there was no real project, because the company filed, got the approval, and then immediately the person transferred to another employer October 1st. That's a big indicator that you never had any intention to work for that company and the company never had any intention to employ you. I think that that's a huge risk to take, and I would not recommend it.
Gia has this question from YouTube. Her visa, she's filing for the visa extension. I'm assuming, Gia, that it's either H-1B or L-1 extension. And then she is going to file the 485 application. Is she allowed to stay in this country and work in United States? Assuming that the visa extension that you're going to be filing is going to be L1A, L1B, or H1B, you could work in United States while your extension is pending. You can stay in United States while your extension is pending until 8 months. You can stay in United States. Since you're filing the adjustment of status, hopefully so by 8 months, by the time your H-1B gets approved, you might get the EAD approval too. But yeah, you can stay in the country and work up to 240 days if you file L1A, L1B, or H-1B extension.
Ficus from YouTube wants to know if there's a risk in traveling outside the U.S. while an H-1B transfer is in progress. He mentions that he'll be getting the stamping done, but for the current employer during the visit. So if you're working for your current employer and going for stamping for your current employer, but you have a transfer in process, technically that's doable, but when you're coming back in, the question would be, which company do you intend to work for? Assuming that you still only intend to work for the original company, then you can come in and work for the original company. But that probably not the best time to file the transfer. The better option, if you have to travel, would be to travel first, get the visa stamp, come back in, and then once you're back with the current employer, file a transfer after that point.
Joel has this question from YouTube that his statement of work is expiring within few weeks, and he's submitting the RFE. What should be done on that? Joel, if your statement of work is expiring right now and you're submitting the RFE, please assume that your H-1B most probably might be only approved until the statement of work is expiring. Let's say if you're responding right now and your statement of work is expiring in February 1st, you may want to file another extension right now. even if you don't have a statement of work, because you may get the H-1B approval in February 2nd week, that is only valid until February 1st week. So even if you don't have a statement of work, you can file an extension. When the RFE comes in, you may want to supply with the fresh statement of work. So these tactical decisions are to be made well before, not after you get the decision, Emily.
Yeah, Vikrant from YouTube wants to know if he has to appear for the H-1B interview again and get the visa stamped again when he changes employer. He's planning to travel to India this year, and his current H-1B visa stamp is valid until September 2022. So the good news is no, if you are continuing an H-1B status but with a new employer, you do not need to get the stamp again. That H-1B visa stamp remains valid until it expires, even if it's with an old employer. So you would just enter using your new I-797 approval notice and your old employer's visa stamp. Be careful when you're coming in to make sure that they give you the end date on your new I-94 that matches your new I-797. We see a lot of times where the officers will mistakenly put the end date to match the visa stamp, which is not correct. So if you catch it right there before you leave, you can have it corrected. If you don't catch it, it's a bigger hassle. Some people don't catch it until the I-94 is already expired, which is an even bigger hassle. So that's one thing to just be careful of when you're coming in like that.
This question comes live. I don't want to name the person. The person's wife may have worked when the person was on OPT. Right now, she is on H4. Will she have any problem coming back into the United States? I would recommend that you contact a lawyer before she travels back into the United States. It would be better to speak and make sure that everybody has all the information up front so that things can be avoided.
Janae from YouTube wants to know what is the status of the H-4 EAD litigation and what's going on with the proposed rule to remove the H-4 EAD. So yeah, we have two processes going on. Ever since the H-4 EAD has been in existence, there's been a lawsuit pending to basically remove the H-4 EAD. It had reached up to the appeals court, and then it was put on hold, and now it's no longer on hold. So that case is moving forward, but these court cases do take a lot of time, and it's likely that they're just going to be looking at some of the technical issues, because whether the case was properly dismissed, whether the people who brought the lawsuit, the U.S. workers, actually have standing to bring the lawsuit. So that lawsuit, probably we're not going to see any answer in the near future. At the same time, we have, according to the regulatory agenda, possibly in the spring of 2020, we might see a proposed regulation to eliminate the H-4 EAD. So that is still the plan as of now. It's just going to be a proposal, so that doesn't mean it will actually be finalized or implemented. We'll have a chance to comment on that. Likely to see lots of comments, and it'll probably take a long time for them to review them, come up with a final rule, and if they do finally decide to eliminate the H-4 EAD, you can bet there's going to be at least one lawsuit trying to keep it active. So nothing burning right now on that, but yes, in the future we may see elimination of that.
I need your attention, Emily. First is, when would the USCIS release step-by-step information how the lottery can be filed? Do you have a date estimate?
Oh, if memory serves, I believe they have to put an announcement in the Federal Register 30 days before March 1st. So we should be seeing something, I would expect, by the end of January with actual instructions on how that's going to work.
The question comes from Sai Krishna is that will this lottery this year, will we find the results sooner? Yes, much sooner than previously, because before April 1st itself, you will have the results, you will have the information whether your name is selected in the lottery or not. This is much more comfortable compared to the previous years.
Vikram from Facebook is working on H-1B now, and his wife is currently on F-1, who is working on OPT. He wants to know if he can leave his H-1B job and do a change of status to F-2 and then later come back to H-1B in the future. So technically, yes, that can be done, but practically you're going to have a hard time. because the change of status from H-1B to F-2 can take anywhere from 6 to 18 months. So if your H-1B is expiring during that time, you won't have a way to get that approved. Also, assuming her OPT is only a 1-year OPT, it's likely expiring sometime. So it's very possible your F-2 might not even be approved in time before her OPT ends. Technically, you could go for F-2 stamping, but remember with the F-1 and F-2, you have to convince USCIS or the CBP or the consular officer that at the end of the program you're going to return home and the purpose of your entry is to study. Here, her studies are already done, and are you going to be able to convince an officer or a consular officer that when her OPT is over, you're both going to leave the United States? Probably difficult to do, especially since you've already been here, already had H-1B. So I think it's probably unlikely that that would work out.
Priya has this question that her husband's H-1B has been approved, H-4 is still pending with the Nebraska Service Center, H-4 EAD has been filed with Vermont Service Center. If I litigate, will both H-4 and EAD will get approved? Yes, Priya, we had no problem when both were two different service centers to get it approved from the litigation though. However, I just want to point out that that previously, before the Christmas, all the H4s and EADs, 99% of them used to get approved within 60 days. However, recently though, the USCIS, because of the holiday period, they requested some extensions. They responded some of those things. It's taking a little bit longer time than previously, what we have quoted in our previous videos with regards to the H4 EAD litigation. I just want to bring it to everybody's attention that. But it is still worth going to litigation. Otherwise, the length of waiting period for H4 plus EAD is going up and up every month. So I still believe that going through the litigation is very good, but that 60-day period that we have told previously, it's getting a little bit weaker now.
Carlos from YouTube has an L-1B that's expiring this coming March, and his company has applied for his green card. His attorney is planning to file an F-1 for his wife in order to gain time, and he wants to know if this is a normal strategy. So a couple questions would be, I'm assuming when you say your L-1's expiring in March, I'm guessing that's the 5-year limit, so you don't have additional time. When you say the company applied for the green card, do you mean through the PERM process, and where are you at within that process? Is your I-140 approved yet? Are you just waiting for your priority date to become current? Getting the spouse on F-1 potentially could be an option to buy more time, but to file the change of status to F-1, she has to be maintaining L2 status all the way through the F-1 processing until it's approved, which, as I've mentioned before, can take anywhere from 6 to 18 months. So for L2's expiring in March and she has no way to extend it, it's going to require a B2 bridge in between. So it's going to be a much more complicated process. Yes, could she go for the visa interview instead and apply at the consulate? That would be faster, but when you've got your green card in process, how is she going to prove that her intent is temporary, which is required for the F-1? So yeah, kind of a lot of questions there. Definitely would need more information to determine whether that's a good strategy or not.
Vivek got an email. Vivek from Facebook has a question. He got an email that that the USCIS has sent an intent to revoke. His H-1B I-94 is valid until September 2020. Will it be in problem if they revoke the H-1B? Yes. If the revocation occurs because of any fraud or any misrepresentation, it goes back to the original application. So that's going to be definitely troublesome. Once you get an intent to revoke, I don't know if I would believe on the email, but once you get the intent to revoke, I would definitely consult a lawyer. Shauri Kapadi from Facebook has this question. Can she sue the California DMV for not giving license based on the H-4 extension receipt notice? Wow, that would be a good case to go to the federal court. Why, when you're allowed to stay in the United States, why is California denying the driving license. It's definitely a good case. Shauri, we are not the proper lawyers for it. If you were to do the crowdfunding, I will fund a certain amount of money for you to go for the litigation. And I think so all the people should contribute to Sauri to go for it, because it's not just one person that is getting affected. A lot of people are getting affected. Yes, you should. I mean, that's the things that need to be brought out. I think so. There was a case from Arizona that went all the way to Supreme Court, so most probably they should learn lessons from it. You are allowed to stay in this country. Why is the California DMV not giving you the driving license? Come on, that should be sued.
Ram from Facebook has his current H-1B expiring next month and not filed the extension yet because he filed a transfer, but that got an RFE on specialty occupation. So he wants to know what options he has to protect his H-1B status. So whichever option you choose, you need to make sure that you do it before your current H-1B expires, which looks like that's February 7th. So you could ask your current employer to file the H-1B extension to allow you to continue your status with that company while the transfer gets worked out. You could have another company file a transfer by February 7th. You could file a change of status to any other status that you qualify for while that transfer RFE is being worked out. And if the RFE gets approved, great, you can withdraw all those other things. If it gets denied, you're at least in a period of authorized stay based on either the other pending extension, the pending transfer, or the pending change of status that was timely filed.
The question from is that the L1 and L2 applications are pending for 240 days. Can we now convert into premium processing? Does the premium processing will cause an RFE? The first concept that the premium processing is going to cause RFE is the biggest lie. Please note it down that yes, RFEs are coming faster when you do premium processing. They come later when you don't do premium processing, but there's no difference between RFE coming just because you are filing a premium processing. And the second question to answer is that if you have filed in the normal processing, you can always convert into premium processing on L1s and H1s. You can always do, absolutely not a problem. The other thing is that if your I-94 has already expired and it's been more than 240 days, you should stop working. The rule is that you're only allowed up to 240 days in L1 and in H1B cases to work. After that, you should stop working.
A question from Facebook, I can't read the name, I'm sorry. Can you briefly tell what's the process for the green card application and what could happen if you change your job while the green card process is going on? So the green card for most people in the employment-based category is a three-step process. The first step, the employer goes through the Labor Department and must prove to the Labor Department that there's a shortage of U.S. workers available in your area for your specific job. They do this through several advertising process, basically trying to recruit U.S. workers. If they can't find any, when all is said and done, the Labor Department will certify that there's a shortage of U.S. workers and issue a labor certification approval. That's step one, done through the Department of Labor. Step two moves to the Immigration Service, where the company then files an I-140 immigrant petition. In that, the company proves that they received that approved labor certification, that they have a job offer available for you, that you qualify for the job based on the education and experience required for it, and the company has the ability to pay the salary that they've offered you. So once that's filed, it can be done in premium processing, so you could get an approval in potentially 2 weeks. Regular processing may be closer to 6 to 8 months. The third step is either filing the adjustment of status or moving through consular processing, which I talked about earlier in the video. So assuming you're going through the adjustment of status process, which most people do, you can only file that step when a green card is available to you based on the visa bulletin, either the dates for filing chart or the dates, final action dates chart. Very complicated. But once it's available for you, you can file the last step, which is the I-485 application, go through an interview at your local office, and then receive the green card approval. When it comes to changing employers, it always depends on where you're at in the process. If you're changing employers during the labor certification step, the process basically stops. When you move to the new employer has to start from scratch with a new labor certification process. If you are changing employers after your I-140 is approved and it's been at least 180 days, but you've not yet been able to file your 485, when you move to a new employer, the new employer does have to do the whole process again, but you can keep your place in line. It's called retaining your priority date, which is the date the first company filed the labor certification for you. Option 3, if you've gotten to the point where you finally filed your 485 and you've waited 180 days and then you change employers, you may be able to take the whole process with you to the new employer as long as the new job is in a same or similar occupation category. The new employer has to file what's called an I-485 Supplement J. Anything I missed?
Heard that L1, L2 extensions are taking a long time. Can we do the premium for L2? Absolutely. Everything is taking a long time right now, period. One thing, Vivek, is that yes, you can do premium processing for L1, but unfortunately, they used to adjudicate the L2s and EADs along with the L1s. They are not doing it anymore. The only way is to go through the litigation process. Reddy Neumann PC takes approximately about 50 people every other week to go to court to get these things adjudicated faster. That's the only way we know to get the cases adjudicated faster.
Priya from YouTube wants to know if the LCA filed by employer A needs to match what's filed by employer B when filing a transfer, and what if the pay rate with employer B is less for some reason. So actually there's no relationship between what your employer A has filed and what your employer B has filed. The only requirement is they be offering you a job that qualifies as a specialty occupation, that they are paying a salary that meets or exceeds the prevailing wage. That's about it. So it doesn't really matter, and that you qualify for the job. So whatever your first employer, if they called you a Java developer, that does not mean you're stuck being a Java developer for the rest of your life while you're on H-1B. You can move up to a team lead and file an H-1B transfer. You can move to anything else that qualifies as a specialty occupation and that your education qualifies you for.
Sandeep has a very legally challenging question to the lawyers. Sandeep, I'm a lawyer in both the countries. I think so. I'm a little bit good in jurisprudence. With regards to his question is that, can the arrest lead to revocation even if the court has completely given a clean record? There are two questions he asked, so I'm going to separate them. Assuming that if your court case has been completely dropped, dismissed, not because you paid money or if the prosecution dismissed, it may still lead to revocation, especially in the DWI cases. The reason behind it is that once the defense that you have when you are in the criminal prosecution is not available when you are in the civil prosecution. So when the immigration is concerned, though, it's not a criminal prosecution, so you don't have the equal rights. In the criminal law, you are proven you are innocent until you are proven guilty. But unfortunately, in the immigration, you are guilty unless proven otherwise. So once you have an arrest, they may revoke your visa status. I strongly recommend, even if you don't receive any letter from the consulate, if you're being detained or if you're arrested for any reason, I would strongly recommend to contact a lawyer before you take any steps, because you're right in asking the question. Even if the case has been dropped, even the prosecution has dropped the case, will my visa still be revoked? Yes, there is a good chance for it, especially for DWIs. Then the second question is a completely separate question. Please don't mix these two questions, guys. What he said is that if the court has sealed the record, what is that?
Expunged.
Expunged, yeah. When the court records are expunged, can it still go to the revocation? The expungement has no meaning whatsoever at all in the immigration. Your criminal lawyer might tell you that expungement, you don't have to mention that you've been arrested or you've been convicted or you've been done anything. No. When you come to the immigration lawyer, the first thing that you do is that no expungement. And anywhere when you go to the immigration, the expungement is not work. It doesn't work. When does the expungement work? Yeah, maybe in the public, the record might not be there. When you're applying for the employment, I'm not going to give you any advice. I will tell you to rely on the advice of your criminal lawyer. But when it comes to the immigration law, though, the expungement has no meaning whatsoever at all, or sealed record has no meaning whatsoever at all. It is as you have to mention it, otherwise you'll be in trouble.
Sanjay from Facebook has a good question about the H-1B grace period that we talked about earlier. And he wants to know, how does having a 2-month severance package play into that? So my experience has been that we have been able to count the severance period as employment and start the grace period at the end of the severance pay, assuming that you're continue receiving pay stubs during that time. I think there's a slight risk that USCIS could question whether you were maintaining H-1 status during the severance period because you weren't actually working. Have I actually seen that happen? I don't think so. I've not really had any issues with counting that severance time as H-1B time and then starting the 60-day grace period after that.
Ashmi Lingam from Facebook has this question. Can I transfer to another employer during my 180 days after the I-140 has been filed? Ashwin, the issue here is not filed, approved. If it's been filed, depending on when your labor certification has been filed, you may be even eligible for beyond 6 years, depending on when the labor certification has been filed. The 180 days is after the approval though, so now it's not before the approval. I strongly recommend that you get the H-1B, I strongly recommend you get the I-140 approved, wait until it's 180 days before you transfer to another company.
JVV from YouTube has a question, currently on H-4 and attending school. I'm assuming a bachelor's degree, and wants to know if they can work for the university as a teaching assistant while in H-4 status. Unfortunately for H-4 dependent kids, that is not, and I apologize for calling you a kid, but you're a dependent. Unfortunately, that's not an option. So you would need to convert to F-1 status to have that capability. And your follow-up question is, if you do convert to F-1, will that kick you out of your parents' ongoing green card process? That answer is no. So as long as you are under 21, you will continue under your parents' green card process and can file your adjustment of status along with them, even if you are not on their dependent H-4 visa anymore and you're on your own independent F-1.
Santosh has this question. His F-1 visa is expiring and he has the OPT status, STEM extension valid status for about 2 more years. What are his probabilities for him to get the visa stamping in India again? Santosh, if ever you are doing that, make sure you sell everything, sell your car, sell everything, go there, you get the visa, you come back. I would not go. I would say that it's less than 50% chance that you're going to get back, because you have to prove to the satisfaction of the consular officer again and again here that you're going to come back after you complete your OPT or STEM extension that you have. So I wouldn't do that.
Zane from YouTube wants to know if he can work for a U.S. company remotely from Canada, and can he maintain his H-1 status while he's doing that? Will he be eligible for an H-1 extension in the future? So yes, you can, assuming you have valid work authorization and visa to work in Canada. You can work for a U.S. company while you sit in Canada. Now, if you've previously held H-1 status and now you're going to Canada and going to work there, when you're outside the U.S., there is no U.S. immigration status to maintain, so you're not really maintaining your H-1 status, but you're not losing it either. So you're outside the U.S., you are working for your company while you sit in Canada. Anytime in the future, if a U.S. employer wants to sponsor you for an H-1B, they can file it at any time of year. It does not have to go through the cap. You'll only get the remaining period of time that you have left in your 6-year limit, but they can file an H-1B for you. Consular processing, get it approved, go for the new visa stamp, and come back and recapture your H-1B status. So yes, that is definitely doable.
Tarun has this follow-up question. He now says that his I-140 is approved in December 2019. His employer is not going to revoke the I-140. Can he move to a different company? Is it recommended that you stay until 6 months until after the I-140 is approved? Tarun, the rule is that the I-140 should not be withdrawn within 6 months. If it's not withdrawn within 6 months, that practically becomes yours. So if the employer, which seems to be a very nice employer, if he's not going to revoke the I-140, yes, you can move to a different employer. If they're not going to revoke within 6 months, that I-140 will become to you. There is no rule that you have to stay with their company for 6 months. The rule is only that the employer must not withdraw within 180 days. So in your case, your employer is cooperative. If you want to line it, that looks to be fine to me.
Amelia from Facebook, her husband is in H-1B status but has never been for stamping, so I assumed filed a change of status here in the U.S. and it now has this extension. They got married here in the U.S. and she's planning to apply for her H-4 stamping once her OPT expires. She wants to know if it's okay for her to go for stamping for the first time even though her husband has never been for stamping. Yes, that is totally fine. There's no requirement that your spouse obtain the H-1B stamp first before you're eligible for your H-4 stamp. You can apply for it based on his H-1B approval notice and currently valid H-1B status.
I have this last question, Emily. It's almost 6 o'clock. The question is that Suresh from Facebook has this question. I have my I-140 approved. My wife is not included in the application at the time when he filed the I-140 application. Will we need to file another I-140? The same I-140 is okay for her to file the adjustment of status. Absolutely, the same I-140 is used. You don't need to file any other I-140 adding your wife. You don't need any other I-140 for your wife. The same I-140 can be used, no problem at all, to filing the adjustment of status.
All right, I think it's about time to wrap it up. I know we had a lot of questions today that we weren't able to get to. So please know that we also have a daily conference call that's free. You can call in and ask your immigration questions there. That schedule and the login information is on our website at rnlawgroup.com. And you can also subscribe to my blog, immigrationgirl.com, to keep up to date on the latest. And I do answer questions that are posted there as well.
Thank you guys for coming in.